Good evening, Section Z. We have been looking at Chapter 12 on takings jurisprudence, and we have looked at the balancing test that the Supreme Court has applied to decide whether a regulation by the government should be deemed to be a taking. Now we're going to look at a case that establishes a categorical rule, a bright line rule, saying that in a certain circumstance, a certain category of government regulation will be deemed to be a taking. And so the case that we're going to look at is Loretto versus Teleprompter Manhattan. In this case, the plaintiff was the owner of an apartment building in New York, and New York had passed a law requiring apartment building owners to permit the installation of cable TV wires. And so under that law, Teleprompter had installed a cable on the plaintiff's roof. They had installed a couple of directional taps, like 4-inch cubed, and then 2 large silver boxes. And then a wire had been dropped down the front of the building to service the tenants. These items were nailed or stapled or bolted to the building. And the plaintiff received $1 in payment for allowing the wire. So the court has to decide, does this regulation requiring the apartment building owner to allow the installation of a wire amount to a taking of property requiring just compensation? Court examines its prior case law and finds there a principle that a permanent physical occupation of property will be deemed to be a taking. And so over on page 649, they say, when the physical intrusion reaches the extreme form of a permanent physical occupation, a taking has occurred. In such a case, the character of government action not only is an important factor in resolving whether the action works a taking, but also is determinative. Now, think about the public use issue for a moment. In Kelo, we saw the court trying to decide whether a taking of property was for a public use. The court does not address that in this opinion, but suppose it had. What if the building owner claimed that this was just a transfer of her property to the private cable company for private use? The Court of Appeals in this case had concluded that the ordinance served a legitimate public purpose of rapid development of and maximum penetration by means of communication, which has important educational and community aspects. So under the Kelo standard, maybe that's enough to establish that this is for public use. Let's imagine another hypothetical. Imagine that government agents run a wire into one of the plaintiff's apartments, but they're doing it for the purpose of surveillance on a tenant. They want to record what a tenant is saying and doing. And they have the wire there for a couple months, but after that, they remove it. Would that be a taking under this opinion? And the answer is no. It might be a taking under the balancing test. You at least could make the argument. You'd have to weigh the factors, but that would not be a per se taking under the Loretto test because it would not be permanent. And so on 649 at the bottom, the court says the cases state or imply that a physical invasion is subject to a balancing process, but they do not suggest that a permanent physical occupation would ever be exempt from the takings clause. So you apply the balancing test if there's a physical occupation, but if it's permanent, you automatically conclude it's a taking. So why are physical invasions of property that are permanent subject to a per se rule when other physical invasions are going to be analyzed under a balancing test? And the court thinks that a permanent physical occupation of property is unusual in that it deprives the owner of several things that are important. The ability to possess the property that is being used, the ability to exclude others from that property, the ability to use and dispose of the occupied portion of the property. And that these are such significant invasions of property rights that we should deem it to be a taking whenever it occurs. And so I don't have much trouble with that idea if the government is like building a building on your property or something, right? For permanent physical occupation of a significant piece of land that you no longer can use or exclude other people from, this ruling makes sense. Does it make sense though when the permanent physical occupation that we're talking about is something so tiny, just a little wire? I guess there are some significant boxes attached to the building, but they're up on the roof. And so, do they really kind of prevent the plaintiff from using her building? Well, they make it less convenient to walk around on the roof, maybe. Maybe if she wanted to build something up on the roof, they would interfere. Has the wire made it impossible to dispose of her building? Probably not. If anything, it might actually make the building more valuable because it is cable ready. So another case, imagine that the government built a dam, and as a result of the dam, every once in a while there was flooding on a person's land. Is that a per se taking under this rule, or is that subject to a balancing test? If you take a look at 650, footnote 1, they address this question. They say, there we go. Not every physical invasion is a taking, and they cite some cases. The intermittent flooding cases reveal that temporary limitations are subject to a more complex balancing process to determine whether they are a taking. And so, think about whether that distinction makes sense. The flooding may actually cause more damage to property than this little wire does, and yet this wire is deemed to be a taking, and the flooding may or may not, depending on application of the balancing test. Now, what if the city has a regulation requiring the owner of an apartment to put in equipment like smoke detectors or fire extinguishers in the hallway? Is that a taking of property? The dissent suggests, yeah, that should be a taking too under this opinion, because your property is permanently occupied as a result of a government regulation. But the majority says, no, actually those cases are distinguishable. So on 652 and 653, they say, there we go. Our holding today in no way alters the analysis governing the state's power to require landlords to comply with building codes and provide utility connections, mailboxes, smoke detectors, fire extinguishers, and the like in the common area of a building, so long as these regulations do not require the landlord to suffer the physical occupation of a portion of his building by a third party. They will be analyzed under the multi-factor inquiry generally applicable to non-possessory governmental activity. So if it's the landlord installing it to comply with the regulation, you do a balancing test. But if it's a third party installing it and the landlord can't prevent it, then it's a per se taking. So is there a way that the city could have accomplished something like this regulation and yet still made sure that tenants had access to cable service? Well, maybe. Footnote 4. Maybe the court suggests it would present a different question if the regulation required landlords to provide a cable installation to a tenant if they so desired. So maybe that would be under the balancing test instead of a per se taking. But court here says that there is a taking, and so we have to award just compensation. On remand, we find out that the court evaluating the just compensation decided that the $1 that was received by the landlord was actually adequate compensation because the TV installation actually increased the value of a typical apartment building. In note 1, after the case, the authors focus on whether we really have satisfied or have accomplished the purpose that Justice Marshall was trying to accomplish when he says that per se rule helps you to avoid difficult line drawing problems, right? And they point out that you have to draw some lines to apply the majority's rule. You have to decide whether a an occupation of the property is permanent, whether it's physical. Are those less difficult issues? Maybe. Um, Notice note 2, focusing on some later cases, and particularly the Yee case versus City of Escondido. There you had a rent control ordinance, and the question is, well, if the city is telling me that I have to allow a tenant to stay in my building and continue paying the rent that they have been paying in the past, is that a permanent physical occupation of my building that is a per se taking? And in the Yee case, the court decides, well, rent control is not a permanent physical occupation because the initial occupation of the property was voluntary. The landlord decided to permit the tenant to move in initially, and so that's not the same as the Loretto situation. But it makes you wonder, could the court have resolved the Loretto case on that principle? What if uh, the wire you could show was actually already attached to the building when the plaintiff bought it, and that when it was initially attached, that it was attached voluntarily? Maybe it would be a different case in that situation. Now think back to the Brasalt case, which was the Rails to Trails Act case from Vermont, where a railroad line had been converted into a hiking and biking trail. In that case, you had people using the trail sometimes, but presumably there are times when the trail was not being used. So is that a permanent physical occupation of the property, or is it intermittent and therefore should be evaluated under a balancing test? I think in that case, probably you would say that the paved path that they were using, that was a permanent physical occupation, and that's enough to decide that it was a per se taking in that case. So enough about Loretto. We will move on to some other important case law after this.